Greetings, everyone. My name is Zareen Glenn with my legal aspects of media, and I'm here just to discuss a few brief discussions of a few defamation cases. The first case I want to start with is the Sullivan versus New York Times and Company. The parties involved in this case are the New York Times and Company and L.B. Sullivan, who was an Alabama public commissioner. The facts that led to their dispute was an article that was published on March 29, 1960, titled Heed Their Rising Voices. This article published inaccurate information which was used maliciously against Sullivan. Sullivan was the Commissioner of Public Affairs, which included the Police Department, Fire Department, Department of Cemetery, and Department of Scales. The article expressed details from a civil rights incident involving students of Alabama State College. This story gave a description of a wave of terror committed by the Montgomery Police Department against the Negro students who were demonstrating a nonviolent protest for their right to vote. It stated that the Montgomery police were ringing the campus by terrorizing the students. The article said that the students sang "My Country 'Tis of Thee" on the state capitol steps, and their leaders were expelled. When the entire student body protested the expulsion by not re-registering, the dining hall was padlocked by the state authorities as an attempt to starve them. The article also stated that the Montgomery Police Department arrested Dr. Martin Luther King Jr. 7 times, and that he was being charged with perjury, which he would face up to 10 years in prison. The facts of the case was that the accurate information was later published was that the students sang the national anthem on the state capitol steps and not "My Country 'Tis of Thee." Only 9 students were expelled by the State Board of Education, but they were expelled for demanding service at a lunch counter in Montgomery County Courthouse on another day. Most of the student body, not all, had protested the expulsion, not by refusing to register, but by boycotting classes on a single day. The dining hall was not padlocked. The only students who may have been barred from eating were the few who had neither signed a pre-registration application nor requested temporary meal tickets. The police did not ring the campus. They were called on campus in connection with the demonstration on the state capitol. Dr. Martin Luther King Jr. was only arrested 4 times. He claimed to have been assaulted years earlier in connection with his arrest to loitering outside a courtroom. One of the officers who made the arrest denied that there was any assault, and 3 of the 4 arrests took place before Sullivan became commissioner. Although he was not named, Sullivan argued that the false statements in the article damaged his reputation because he was in charge of the public affairs. He felt as if when the public read about the events that occurred, he would be placed as part of the blame because he supervised the police department that committed these allegations. Although he had received a payment for damages in the amount of $500,000, New York Times wanted to appeal the verdict from the state of Alabama. Since Sullivan was filing for defamation, he had to prove that his reputation was damaged. Sullivan had to have tangible evidence showing that this article alone had damaged his name, his brand, or his career. The elements of defamation show that factual error, content defamatory of official reputation, nor both are sufficient to warrant an award of damages for false statements unless actual malice is alleged or proved. The U.S. Supreme Court ruled in favor of the New York Times because the petitioner had insufficient evidence that his reputation was damaged, and under the First and 14th Amendment, an elected official cannot be awarded for damages unless actual malice has been proven. The second case that I want to discuss with you all today is the Gertz versus Welts Incorporated. The parties in this case are Elmer Gertz, who was a private attorney who was representing a Chicago police officer who had shot and killed a child. Officer Richard Nuccio was charged with homicide for the death of a youth named Nelson and was later charged with second-degree murder. Welch Incorporated is the other party who made a publication with defamatory statements about Gertz's legal career. Welsh Incorporated published an article stated the American Opinion article, and it stated that the testimony against Nuccio during his trial was false and that his prosecution was part of a communist campaign against the police. The article stated that the petitioner had been an official of the Marx League for Industrial Democracy. This was originally known as the Intercollegiate Socialist Society that advocated a violent seizure of our government. The article also labeled Gertz as a Leninist and a communist fronter. The article also stated that Gertz was an officer of the National Lawyers Guild that was described as a communist organization that probably did more than any other outfit to plan the communist attack on the Chicago police during the 1968 Democratic Convention. Nothing was done to verify these statements. The editing manager instead appended an editorial introduction stating that the author did extensive research in the Richard Nuccio case. The article included a picture of Gertz and wrote, "Elmer Gertz of Red Guild harasses Nuccio," as the caption below. Without any doubt, I am definitely sure that the article raised many questions to any past, current, and future clients Gertz would have represented. I wouldn't doubt that they were questioning the judgment of his work. This would have the public questioning his private life and his views of government. Defamation can tarnish a person's name and image. I believe that these allegations made it very difficult for him to partner with any attorney. His future work would also be clouded by these false judgments. For a better outcome, to avoid a lawsuit, I would have verified the information before the article was published. There should have been more research done on the organizations before associating Gertz with any communist group. If it were possible, I would have conducted an interview with Gertz myself and asked him to give any clarity on any of the groups that he may have been associated with. In the state of South Carolina, where I'm located, the defamation law states a person may bring an action of defamation in a court of law to one's reputation, and the plaintiffs must prove that their respective defendants made a false statements of fact, caused marital or reputational harm, and the defendant acted either negligently, recklessly, or with actual malice when disseminating the material. The information that I gathered from both of these cases was to verify all information before getting it documented for the public. Defamation can ruin a person for just as false allegations. What may have taken a person a lifetime to build can be destroyed within a matter of seconds of reckless actions. I always want to put myself in the other person's shoes and think of how I would be affected and to see things from an opposite perspective. This comes into play with anything you say, publish, and post. If it is not a proven fact, it is only an opinion. And although we have the freedom of press and speech, this does not always protect the manner of a libel suit.